please subscribe and don't forget to press the bell icon to get notified whenever we upload a new video.
Important, not just that they have blown out the Binani bid, but the reasons for which they have blown it out. If you remember, the Dalmia Group has already written to the CVC and to the Reserve Bank. That's a story we broke, claiming that if you could have paid your money, you should have paid your money when you owed the banks. To come when you realize that the asset is slipping out of your hands, to then strike a deal with the H2, bypassing the H1 was basically by the CVC norms something illegal and unethical. So, the Supreme Court's order seems to be in line with these arguments. Can you repeat for us once again the Supreme Court's reasons for throwing out the Binani petition?
Well, to be certain, the order is yet to come out, but I can take you through the observations that the Apex Court has given, and these observations are quite startling. The Apex Court has said that it is an undisputed fact that UltraTech was an interested party. It did try to participate as far as the bidding process is concerned, but lost out. It is also admitted, it is out in the open, that UltraTech is trying to buy a shareholding, and that that reduces Binani Industries to merely a front. The Apex Court also observing that as far as Binani is concerned, it is a mere proxy in this case, that UltraTech is putting up a bidder in the form of Binani Industries, and that this, according to the Apex Court, is where the cat comes out of the bag, that Binani Industries has taken money from UltraTech, is a front for it, is a proxy for it, and that what could not have been achieved directly is being sought to achieve through indirect means. That was the broad reasoning that the Apex Court has given, not seeing this essentially as being foul of the IBC process, which interestingly was the argument of Dalmia Industries itself, that as far as this Dalmia Bharat, I beg your pardon, has been, that should such an out-of-court settlement be permitted, it will lead to the collapse of the IBC regime, because no serious bidder will present himself or herself at the time of the resolution process, knowing that there can be possible extra statutory means through out-of-court settlements where the entire bid can be defeated. This was the very argument that, in fact, had been forwarded by Dalmia Bharat. The Apex Court clearly agreeing with that, and as of right now, shooting down Binani Industries' application, not passing muster, this out-of-court settlement offer, and now the Apex Court giving Binani Industries liberty to withdraw their application.
Okay, in fact, let's
just stay on, Ashmit. We have a lawyer with us. Rajendra Chitale, advisor, Chitale Legal, has joined us. Rajendra, can you tell us what this seminal order from the Supreme Court means? What is the message they are sending both to defaulting promoters and to other bidders?
Yeah, I think from what I heard the Supreme Court saying is that the integrity of the resolution process is paramount. And if indeed an alternative route is being sought to basically achieve what could not have been achieved by preserving the integrity of the original process, that doesn't seem to meet the test of approval from the Supreme Court. So at some level, I think we are now seeing a scenario where the integrity of the process is actually restored, and going forward, the ability to be financially correct or do better financially would therefore rest on whether the process itself can be refined to provide for competitive bidding, which can go on like it happens in other auctions, rather than purely having H1 and then negotiate with H1.
Okay, Rajendra, does this make does it increase the onus on the creditors committee or the IRP in any way?
Well, I don't think it increases the onus. It simply suggests that for them, it's important that they go back to the drawing board and see whether there can be a refinement of the process itself to maximize the outcome for the lenders without compromise. So within the process itself, whether an improvement is possible to do better, so that it doesn't happen that you have H1, which then is opened, and that's the only party. And if there is a way of creating additional pressure on bidders to improve their deal, just like it happens in other auctions. If that process could become feasible, that's then a matter of evolution for the creditors committee.
Okay. Does it also ensure that now defaulters learn a seminal lesson that the Supreme Court is fully backing the process laid down by the ordinance and the eventual amendment of the IBC, that defaulters cannot come in through the back door?
Oh, absolutely. Absolutely. There is no question about that.
All right, I think we have Mr. H.P. Ranina as well, who joins in. Mr. Ranina, well, this is a landmark judgment. The Supreme Court has refused that offer, that out-of-court offer. Okay, all right, I think we'll get back to Mr. Ranina shortly. But just to tell our viewers, Dalmia Bharat has moved to the high point of the day, because with this acquisition, they have the potential to move from around 30 million tons to around 40 million tons. So we don't have the exact numbers, but the last time we spoke to Dalmia Bharat, they indicated that number was roughly around 6,500 crores to around 6,700 crores. And that will help them really get access to a new geography. So that's why that stock is moving higher. Binani Industries, remember, there was a hope trade that was playing out. There was no guarantee, irrespective of who gets Binani Cement, whether Binani Industries shareholders will get anything. For the time being, there's still fun and games going on to there, because there's no guarantee whatsoever, whichever direction this asset goes. Binani Industries, remember, that's the company that owns Binani Cement, and Binani Cement is being sold. So there's no guarantee that they were going to get anything. That moved to the low point of the day, and that spiked up. UltraTech Cement, you know, there's two views of looking at it. One way is that, in fact, they're going ahead, they're acquiring a new asset which is best in quality. They consolidate their position. So in the last couple of weeks, in fact, the street was mixed whether or not they should go for this asset or not. And similar was the case for Dalmia Bharat as well. But UltraTech consolidating their position would have been actually a positive if they got this asset, Binani Cement. They have a large proportion in that, you know, of the market share out there. And this would have really helped their market share.
Okay. Well, before we say goodbye to Rajendra Shitale, any further observations with what the Supreme Court has said and what it means to the IBC process? A great beginning, you would say?
I think so, because I think it puts to rest once and for all the doubts about whether there can be a track 2 when the IBC process is on. And clearly, Supreme Court has said there is only one track, and that is the track that has to be taken by all in one.
Okay. Thank you very much, Rajendra, for joining us with your observations. This is the Supreme Court fully backing and endorsing the IBC process, saying that you cannot have, you know, this kind of cheating, you know, a second bidder tying up with the defaulter. So there is no backdoor entry for the defaulter. And in a clean bidding process, H1 gets it, and H2 can't have H2 or H3 or H4 can't have other ways of defiling the process. So it's a very important direction that the Supreme Court has given, and will stand in good stead for future IBC cases that will come.
Okay, so this case will definitely set, this judgment by the Supreme Court will definitely set a precedent in upholding the tenets of, you know, the Insolvency and Bankruptcy Code. I believe we have Shardul Shroff as well joining us on this landmark judgment passed by the Supreme Court. Afternoon, Mr. Shroff, your initial comments.
I think my position and the stand of our client stands vindicated that this kind of unholy alliance between a disqualified promoter and a losing bidder is not permissible in law, and the court is fully cognizant and has again confirmed the position that the matter has to be resolved under the provisions of the IBC.
Okay, Mr. Shroff, any further observations? Does it will it discipline the defaulters in future as well, that there are no backdoor entries?
Yes, obviously, that the fact that you know, so much hue and cry has been raised by the losing bidder over the last 2 weeks, and you know, sort of doubts have been created that this is something that can be done, has all been put to rest, and that is a good sign. So that promoters should not be encouraged to really you know, go behind the scene and do a backdoor kind of an arrangement when there is a prescription of law. And this will also you know, encourage outside bidders that there is a certainty in the law, and you can't introduce elements which are imponderable elements and, completely skew the game. So I think this is good for the law.
Okay. So separately, even for the bidders, does this introduce a sense that you can't play machinations after a deal is done? Will it therefore invite better bids and maybe even larger bids to the advantage of bankers?
Yeah, absolutely, because it's a clear indication that you put your best bid forward. Don't try to, this is not an auction. So, it's not about, raising one bid and then you lose and then you go again and make another bid. You have to put your best foot forward at the very beginning. And I think that is an unequivocal message which has been given to bidders also.
All right. Mr. Shroff, pleasure having you with us. Thank you very much for joining us with your thoughts. We have
Mr. Mahindra Singhi as well, the Group CEO and whole-time director at Dalmia Bharat. Well, Mr. Singhi, all right, I think Mr. Singhi is with us right now. Mr. Singhi, well, the out-of-court settlement has been ruled out. So
yes,
it appears that it's moving in your favor, sir. Tell us, what's the next course of action now? What's the way forward?
Let me say, a court was very pleased to uphold the law of IPC, and court was very pleased to dismiss the application of both Binani and UltraTech. And now you can just take a bite from Mr. Sundaram and Mr. Paul, who have won the case. Just one minute. Hello.
Yeah, Mr. Singhi, we are losing your voice. If you could put the phone closer. Yeah, tell us, sir.
Can you hear me? Yeah.
Yes, yeah, much better now. Please go ahead.
Yeah. Yes, what is it?
Yeah, I know. We just want to know what are your future plans now that it is well and truly in the bag, Binani Cement?
No, the resolution professional and the COC has approved the bid of our bid, and that is to go ahead with the usual process under the Bankruptcy Code. Today's case was actually because the NCLAT had directed that the matter would proceed under the NCLAT, under the IBC Code, in accordance with law. And the case was filed by both the Binani Industries, the promoters, saying that they want to settle the matter and therefore this should not go through, and instead a settlement should be permitted with the various creditors. And the promoter should continue and UltraTech should come in. So it was argued at some length, and when the court was not inclined to interfere, they have withdrawn the case from the court.
Okay. But now the next step is Dalmia Bharat gets control of Binani Cement. Are there any other hurdles?
The next step is actually that as per the court, now it has to go for approval, and that will go on before NCLT. It's posted for hearing. It will be heard, and so that the overall scheme can be duly considered and approved. So it will go ahead at that stage.
Okay. In most of such cases, do you expect in this case, of course, it's the Binani Industries shareholder. There is no Binani Cement listed or public shareholders. But do shareholders stand a chance?
A chance for what?
I mean, to make any money. If it's a listed share.
Shareholders came before court today. The Binani Cement shareholder, 98%, is held by Binani Industries.
Yes.
And Binani Industries came today and said, give us an opportunity to settle the dues and to pay the creditors.
No. That's not what I meant, sir. That's not what I meant. What I meant is, in a case like this, would public shareholders, of course, in Binani Industries, in Binani Cement, that issue doesn't arise. But in several other cases that have gone to the NCLT, there are public shareholders. Would they have a chance, or if
actually, how the NCLT will consider as a matter subject to the NCLT, which we will consider in that.
Okay.
Just one moment.
All right. I think we have Mr. Singhi as well back with us. I think that was the lawyer of the Dalmia Group who was speaking to us. Mr. Singhi? Mr. Singhi?
Just talk to Mr. Kaul, senior advocate. Council of Dalmia Cements. Hello.
Right. Yes, Mr. Kaul, sir.
Just a moment. Just speak.
Right. A quick comment from you, sir.
Yes. Hello. Yes.
Yes, sir. Tell us your understanding of...
They had, UltraTech had appealed against the NCLAT order, which had directed NCLT to go in accordance with the IBC code. and the court was not inclined to interfere. So
Absolutely.
they withdrew their petition.
Absolutely, sir. So it's gone in your favor, in the favor of your client.
Oh, absolutely.
Absolutely. We just wanted to have a quick word with Mr. Singhi as well before we wind this conversation down.
Mr. Singhi, just a minute. Mr.
Yes,
Singhi.
yes. All right, we'll just wait to get some more clarity from Mr. Singhi as we speak. The stock has spiked up, that is of Dalmia. All right, we'll try to get back with Mr. Singhi. But short point is that Dalmia Bharat, I mean, in terms of a stock market,
now is the owner of Binani.
Is the owner of Binani Cement as we speak. Everything is cleared out for them. Their capacity will go from around 30 million tons, closer towards 40 million tons approximately. There's a greenfield as well over there. I mean, they have a chance to go ahead and add some capacity over there. So we'll wait by. Those are all the details. As of now, the big headline right now is that the out-of-court settlement that was put forth, that really has been done away. That has been brushed aside by the Supreme Court. And now, in fact, Dalmia Bharat will be the owner of Binani Cements. So,
and it will also help in this on-time resolution and settlement of all these insolvent assets. Otherwise, these cases could have gone on and on, moving from NCLT to a Supreme Court. Now, this, now that you just have to stick to IBC and the rules that are stated there, it will help in on-time resolution. Confidence in the system goes up. Ease of doing business, improves.
Oh, absolutely. I mean, actually, ease of doing business. The 30 points we got were all for putting in the IBC. That is the matrix on which we had done the best. And the important part is that, the first case has been settled in such clean manner. But I think we have...
Mr. Singhi, if you can hear us, sir. Sir, we want to understand what is the way forward now. How soon will you get possession of this plant?
Now, first important thing is... important thing is that court has said that there cannot be anything other than IBC for such assets. So that's a great victory for Indian law. That's a great victory for IBC and great victory for the corporate entities who are believing in law. So we are very happy that now we will go to NCLT, we'll get our resolution plan approved, and then in short time we'll make payment to all lenders, and we'll try to take care of each and everyone so that everybody perceives this resolution as a true resolution. And now, in 1 month's time, all things should happen.
Okay. Mr. Singhi, thank you very much for your time. We'll try and reconnect with you some other time. We're also joined by Sameer Kaji, the Senior Advisor of Binani Industries. Mr. Kaji, big blow for the company by the Supreme Court.
I would like to only say one thing. The matter they felt was a bit premature at Supreme Court. We are going to now be heard at NCLT Calcutta on Monday.
Okay. You still hold out hope?
That's the only comment I have at this stage, because it's premature for me to opine.
But will not... Isn't it closed, sir, considering that the Supreme Court has said what it has said? Can the NCLT differ?
I don't think so. I don't think so, because only thing the Supreme Court really said was it's premature. Why are you... The first opening remark also was that Monday you have a hearing at NCLT.
But will not the arguments, Mr. Kazi, be the same at the Supreme Court? The arguments which held in the Supreme Court are likely to be, to hold even at the NCLT.
Let's see. We will chat on Monday. That's why I said. We'll wait and see.
So one question just to you. Your Binani Industries is the listed share. We asked you this last time as well. Irrespective of who gets it, Binani Industries shareholders, will they get anything?
See, with some numbers, I would definitely say the value of the company will definitely go up. Right. Because all these liabilities will eventually reduce or get paid out.
From a shareholder's point of view, sir?
Yeah, from shareholder point of view, they will definitely benefit.
So you're going to return some money to them?
Yes. What quantum, nobody knows at this stage.
Okay. Mr. Kaji, just one question. If on Monday at NCLT Calcutta, the ruling goes against Binani Industries, then would the matter come to an end? Is there still any recourse left?
For me, it's premature to opine on that. Okay. I'm always positive, and we chat on Monday.
All right, Mr. Kaji. We'll leave it at that. Thank you very much for joining us.